May it please court chairman and other court members, before we proceed to have a ruling of this court.
Excuse me, we are still proceeding. If you please let us first finish our submission.
Please sit down.
Thank you very much.
Sit down.
We are still proceeding as defense counsel. We shall not allow you to proceed. Listen to us. We are proceeding as a defense team. We have not finished.
Okay, let them finish their part, then you will reply.
No. So the council has no locus. This is what I'm going to talk about.
No. I have all the locus. Even
No, I
in
mean the one you are introducing.
What are you talking about?
We are not for a fight.
So, Mr. Chairman,
it's their turn. You leave them, let the defense lawyers put up their arguments.
Mr. Chairman, the prayer we are making, if we could be given time to interact with the chosen persons, considering the prevailing circumstances where we have the lead counsel who has that issue, who is incapacitated as of now. So it's not a matter for debate, Mr. Chairman, or for argument and counter-arguments.
Counsel.
I mean, Chairman and members of this honorable court, if I may put this point succinctly, is that the defense team requests this honorable court to talk to the clients, Besigye and Rutare, and then we get effective instructions on how to proceed, because this is not going to be business as usual. Thank you very much.
I wish, Council, you could reduce on your tune. That one has no problem. Council Lord Mayor, what time do you want to talk to him now, or you want to talk to him any other day?
No, we want to talk to him right now, but in the camera, not in public here.
Yes, we can also allow that if it is not going maybe to take a long time.
Like 30 minutes?
Yes.
I think, sir, there are legal issues before you allow them. One, the lead counsel, you are saying she has no instructions as of now. So if she has no instructions, are you saying the case cannot proceed with all these other lawyers you have introduced? And if you are not ready until she acquires a certificate, then it would mean nothing can proceed. Either you seek an adjournment another date, but giving them the minutes still will not make a difference. Because he's saying he cannot proceed without their lead counsel, who is improperly before court.
Honorable Chair, I was very clear. The instructions given are to the effect that Honorable Martha Karua takes charge as the lead counsel. And there are some legal hurdles we have encountered along the way. It is his decision to take any other decision if he so wishes. So this is the matter. This is the issue we are raising. That if there is any adjustment to the instructions, we need to confer with him or with them. So the question is, all along we have been seated outside, we have not had any opportunity of interacting with him. So right now, that's basically what we are seeking for. Like 30 minutes, we agree. We decide on the way forward, we chart the way forward after having a conversation with him over these issues. I am sure he's just getting information about what we have been doing at the law council just right now here. We had not yet even briefed him as to the progress of the matter before the law council. And these are the issues we should be discussing with him.
And for the avoidance of doubt, that's why Honorable Martha is not yet speaking. We want to talk to the two clients so that they allow us, in the meantime for today, to proceed without Honorable Martha leading the team formally, because they may ask themselves that we chose Honorable Martha to lead and we see Rukwago and Karibara. No, so we are trying to consult them to make them appreciate. So for now, Lukwago and Ernest are leading, as you have seen, and they are requesting, the team is requesting to confer with the client for 30 minutes in the camera so that we can effectively represent them. Yes, thank you very much.
You can hear from state because he wanted to talk. They said he was within their time. Can you address court before the chair takes a decision?
Okay, Council Kwagu has introduced a battalion of lawyers, but among them, I think it is only 4 who have complied with Regulation 62 of Uganda People's Defense Forces procedures. That is paragraph 3. And those ones who have complied are Lukwago, Chiza, Narukora, and Masiko. So I think the rest should not be on the record. Yes, they have not complied. Read the regulation. Unless they comply with this regulation, they should not be on the record. Person is entitled to appear as advocates.
Order, please.
So I will simply go to paragraph 3. If an accused is to be defended at his court-martial by an advocate not nominated by the convening authority, the accused shall give the convening authority notice of his fact not less than 24 hours before his trial. So it is only those 4 who have complied with that. Even the document, this document here, which is before court, it is as if it is coming from this court. It is a Republic of Uganda, Uganda People's Defense Forces, in the General Court Martial, ordered at Machine. So this document does not bear the address of this.
Signed by.
I don't know even if the person who signed it. I don't know. So these people are not properly before this order of court.
I think, Councillor Kwago, this goes back to what our judge advocate advised. Maybe to sort out these issues, you could pray for an adjournment and you clearly put everything right.
Prosecution is misleading this court. The instrument is reading was about law firms. It's not about the particulars of the individual advocates. Actually, where I was reading, my name is not there. It's Lukwago and Company Advocates. If we cared enough to look at the list I was reading, he would see the individual advocates and the law firm they come from. They are indicated there. So this is the list. So there's a difference between law firms and individual practicing advocates. For example, Martha Karua on this list is care of Lukwago and Company Advocates. And it is in black and white. So I don't know, his point is neither here nor there. To me, Mr. Chairman, it be considered as a very serious matter. And in any case, the lawyers are here. If you want their particulars, we can furnish them to court. They are here. So those are the things the Constitution intended to cure. Article 126. Maybe it's not applicable in this court. But if the constitution is the fundamental law of the land here, it's very clear. Substantive justice as opposed to those minor technicalities which are neither here nor there. So I don't think we should indulge in those gymnastics, Mr. Chairman.
These are not minor technicalities. Mr. Kwagu, you endeavored to attach your practicing certificate. Chira, you did. This is reimbursed did. And this is in compliance with the law. Why did you do this? So those ones who have not complied shouldn't be on record. Why did you do it and your colleagues? Or why didn't you advise your colleagues also to do the same?
So I don't understand his prayer. Is he suggesting that the lawyers who are not on this list shouldn't even be here? I don't know the prayer he's making.
No, they shouldn't be on the record.
Yes?
They shouldn't be on the record. I think you have not appreciated the regulation. It is not my law. Read it.
I think I want to reiterate the position of the Honorable Ronde Mayor that my colleague in uniform is on a mission to mislead this Honorable Court. And he's doing well in that direction. If he had taken the time to read Article 28 of the Constitution, which I'm going to read for him, Article 28(1) guarantees the right to a fair hearing and guarantees the right to a lawyer of his choice and defense facilities. Article 44, paragraph C of the same Constitution says that this right is not negotiable in my language, but in its speculation it uses English of non-derogable. Notwithstanding anything in this Constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. Paragraph C is the right to a fair hearing. The right to a fair hearing includes the two accused persons choosing their lawyer, which they have done. You can't tell them, even now they can appoint a lawyer. Now as we're proceeding, they can even fire us and replace us. That's fair hearing. That rule you are quoting is null and void. Article 2 of the Constitution is very clear that if any regulation, rule, speech from the prosecution is inconsistent with the Constitution, the words of the Constitution, Chairman and members of this court, is such a things as he is saying are null and void. That is Article 2 of the Constitution. Will this court follow null and void submissions, or will it follow the provisions of this Constitution? Thank you very much.
I don't know where my colleague has got the jurisdiction to pronounce the law null and void. Read Article 137.
Said regulation is not the law.
It is a law regulating the law. So where do you get the mandate? You
Raphael, you have...
I went to law school for 5 years, studied law, and this Constitution was promulgated in 1995, and Article 221, these articles are in my head, says that UPDF shall promote, respect, and protect this Constitution and the fundamental human rights of Ugandans. And we are saying the right